Okay, my name is Nikolai, and today's webinar, as you probably know, is called Church Plans, Legal Tips for the Plans. Today's presenter is Crystal Winkle, and she is assisted by Miriam Sadler. Crystal is our special counsel, and Miriam is one of our lawyers. They both specialize in commercial law as well as not-for-profit law, and I hope you will enjoy your webinar today. For any difficulties with audio, you can call 1-800-733-416. During the webinar, you will be able to ask questions by typing them into a chat box. Keep in mind that every participant will be able to see those questions, so keep that in mind. And as we go along, Crystal or Miriam will be able to answer those questions as the circumstances allow. So obviously as they talk, they will see the questions pop up and they will try their best to answer them. I guess this is all good to go, and the copy of this webinar will be available on our website in about 2 or 3 days. We'll process the file and make it available for you to download and share with your colleagues. I'll pass it on to Crystal and Miriam. Thank you.
Good afternoon, everybody. My name is Crystal Winkler. I'm Special Counsel here at Corney & Lind, and today we'll be talking about the things you've got to think about from a legal perspective if you're looking at planting a church. All right. That's just our little intro slide there. We're a mid-sized law firm. We specialise in a range of areas, including schools and education, not-for-profit and charity, commercial, employment and discrimination, and the rest of them there you see listed. All right, our pictures. Okay, so what are the legal challenges associated when you're planting a new church? As I was thinking about this, I thought, well, the first question that you need to answer when you're looking at planting a church is whether or not you want that brand new church to be an autonomous church, standing apart from its mother church that's planted it, or whether or not you want it to be a part of the mother church, autonomous, not autonomous, within the mother church structure. So the answer to that question will determine how you structure the planted church. All right. So option one is to have the church not independent from the mother church. Now, how does that work? Legally, what the church plant will be, and normally what this looks like is you decide to plant a church, you find a location, you've got a pastor in mind to take over the running of that church. The mother church will, arrange tenure of the premises, whether that's hiring a hall or leasing a building on behalf of the plant. They'll employ the pastor who's going to pastor the plant directly, and that pastor will come in maybe with a team and build a congregation from that point. At that point, the planted church is still really a part of the mother church. It's like an activity of the mother church. So when you're doing all of your financial reporting and from a legal perspective, everything's under the ABN of the mother church. Any employment contracts are directly with the mother church. Contracts for lease of premises or hire of premises are with the mother church. And that planted church comes underneath the mother church. Now, this arrangement might continue for a short period of time until the church is established. It might continue indefinitely. Some churches like to use this activity model as their church planting model or method. Okay. Okay, so what are the benefits of going in this direction, either indefinitely or for a short period of time? Obviously, if it's all one entity, you can easily share resources from one church to another church. There's the sharing of policies, of information, staff, money. It can all just be quite easily and openly shared between the two entities. You can adopt a separate set of rules or regulations or bylaws which specifically will govern the operation of the planted church. So within those rules, you can set out things like who the leadership of that church will be, how you govern the congregation, what happens and how you do things. So you can put all that in these regulations, which sit as a subordinate document underneath the constitution of the church. Obviously, there's a smaller setup cost because there's no new entity. All of the tax endorsements of the mother church apply to the plant. What are the difficulties? Well, from the mother church's perspective, there's shared liability. So if something happens at the church plant, then it's the mother church that bears that liability. So that's a downside. Sometimes the ability to control what happens as well is lesser because obviously the senior pastor mightn't be there. It can be difficult to make sure policies are being implemented properly. Because the mother church is obviously the bigger entity, they can end up bearing more of the financial and regulatory load. Now, this is often one of the reasons why you set it up this way, because the small plant can't bear those burdens, but it can also end up being a burden on the mother church as that plant grows. The other thing to say is, and I've seen this happen before, the church is planted in this way, when the time comes for that plant to be independently incorporated, you've actually got a big task on your hands. I don't know if anyone's ever been involved in a church merger before, but extricating a large plant from a mother church can be just as complicated as merging two reasonably large churches together. So if the intent is to eventually extricate the plant, you're better off doing that sooner rather than later, just from a complexity perspective. All right, so it can be beneficial to set it up this way if the mother church wants to maintain long-term or medium-term control of the plant. The mother church can also choose to retain all power to make decisions because it is the controlling entity. It is essentially the plant from a legal perspective. The board of the mother church can pass resolutions around the hiring of employees, adoption of church policies, where premises are located. Alternatively, it might be that the mother church wants to give all of these decision-making powers to the plant itself, and it can do that as well by appointing a subcommittee which has oversight of the plant. And then there can be reporting back obligations on that subcommittee back to the mother church. Mother church still retains ultimate control in that it can fire and hire a new subcommittee, and it can change the rules of the subcommittee. It can be a good model if you're going with a campus model of church. So you've got the mother church, and then you've got different campuses with location pastors underneath the senior pastor of the mother church. And in those models, the congregation of the plant is seen as part of the larger congregation of the mother church. So when would you think about doing this? Usually when you anticipate the plant will be difficult, and plants are always difficult, but it's exceptionally difficult, and there might be a real need to leverage off the mother church's resources and existing structure for an extended period of time. The good thing is that the plant will have liberty to conduct a full range of activities because it will have all of the corporate protection of the mother church. Okay, so it can engage in, working with children, for example, and be assured that there is corporate protection. Okay. Another point I put there is sometimes the mother church will open membership in the mother church up to the plant congregation if that's the structure of the mother church, to have an open-based membership. They can choose whether or not they want to do that. Obviously, you would only do that if you intended to maintain that structure where the plant is a part of the mother church. All right. The second option, and I'll hand over to Miriam to discuss this option, is where the church will be independent from the mother church, setting the church plant up as an independent entity from the get-go. I'll just hand you over to Miriam.
The portion that I'll be dealing with here, which is the second option for the church plant, the church being established as an entity which is independent from the mother church. So this means essentially that the church plant will be legally a separate entity from the mother church, and its legal structure will therefore be dependent on the initial size of the church. It also will include medium term. The rest of the church it's also worth noting that financial institutions less willing to lend to unincorporated entities because sometimes there is structure, and also because are there some sound issues? It seems like we've got some people reporting sound issues that have gone out there. Okay. All right. So shall I continue? All right. So it seems like the sound issues might have been resolved. Please continue to let us know if that's the case. In terms of, as I said, the risk of the plant, we usually stop with the church plant where it's established as an independent entity from the mother church. So that includes public liability and borrowing. And as I started out to say just before, financial institutions are generally less willing to lend to an unincorporated entity because essentially the entity responsible for then servicing that loan facility, so repaying funds, will end up being the unincorporated church, and there's no guarantee that those funds will be repaid. So if you're looking to raise capital, oftentimes establishing a church independent from the mother church is a good idea. And oftentimes such a church will be established as a company limited by guarantee. This affords a clean separation from the mother church as a legal entity from the very outset, which helps to eliminate some of the administrative confusions which may potentially arise when you're dealing with a church plant which forms part of the activities of the mother church. And it also helps to alleviate long-term or anticipated costs if eventually the church plant grows in size and has to separate from the mother church further down the track. So as I said, an independently planted church separate from the mother church will often be set up as a company limited by guarantee. This is often an option, particularly for churches with access to some startup funds, because obviously there are some greater startup costs associated with establishing or planting that church as a separate corporate entity. However, that does eliminate the risk of duplicating costs if the church wishes to separate or become independent further down the track. This affords leaders under a company limited by guarantee the protection of the corporate veil from the very outset. So if the church is separate from the mother church, not only does that afford a degree of distance and protection for the mother church, but also for the leadership. The corporate veil affords some degree of protection to the leadership of the church so that if an incident occurs, provided of course that the leaders are acting responsibly in accordance with their governance duties, they do not have the same exposure to risk for personal liability for that incident. An incorporated church, in order to be established as such, will generally require, well, it will require its own ABN in order to be registered as a charity, and then some tax endorsements can be provided by the ATO in association with that. The church, when it's established as a company limited by guarantee, will generally have its own legal personality, and that enables it to enter into a lease or to buy premises directly, independently from the mother church. And as I mentioned before, the incorporated church is then able to seek finance in its own name. Generally speaking, an incorporated church as a company limited by guarantee will be controlled by governance rules, such as the Constitution. An ACC constitution for a company limited by guarantee is something that we are able to work with you in developing. However, we do recommend that you seek advice to check that any kind of standard constitution doesn't require any amendments for the purposes of your particular church needs. All right, so moving on, the church will generally require some start-up funds, as I said, in order to make the option of independence from the mother church from the outset a viable alternative. Otherwise, obviously, okay, we've got a question here about, if I can just interject, about briefly explaining the corporate bail. It might be worth interjecting on that subject right now. So essentially, the corporate bail means that because the church has been established as its own separate legal entity, then the church as a company limited by guarantee will in a sense be personally liable rather than the members themselves for any, or the leadership themselves for any incident that occurs. Hang on, we've got no sound.
Essentially what I was saying is that when the law looks at a company, what it sees is the corporate veil. So it sees the company and it doesn't see through that veil to the leaders and the members. Where there is no company, there is no veil. So when there's still some sound issues. How about now? Okay, that's good. That's better. Okay. So I was just saying, where there is no company, there is no veil, which means when the law looks at the church, what it sees is their leaders in their own personal capacities and the members. Okay, so it is those leaders and those members who are liable personally for any claims. Where there is a corporate veil, the law looks at it, it sees the company, it doesn't see through to the leaders and members. Of course, there are exceptions to that, but for the most part, you have the protection of the corporate veil.
Thank you for that, Crystal. Can everybody hear me okay? No further sound issues? Okay, wonderful. We've got a thanks for that. So, yes, as I said, the corporate veil or the protections it affords ensures that the leaders or the members of the church, generally speaking, are afforded a degree of protection from personal liability in the event that there is an incident in the life of the church. That is, however, only when the church is incorporated as its own legal entity. So as I said, a church, in order to make this option viable, will generally require some start-up funds. The alternative, if those kind of start-up funds are not actually available from the outset, is for the church to commence life as an activity within the auspices of the mother church, and thereafter to seek incorporation when the church has reached a certain stage in its growth and development and is ready and has the financial capital to contemplate separating. The more expensive option is obviously this one from the outset, but there are no duplications of costs further down the track. Once it's an established corporate entity, the start-up costs are not repeated, and there's no cost in subsequently extracting the church plant because it has started its life as part of the mother church and then subsequently needs to separate. Where the church plant is incorporated, the leaders are afforded, as we said, the protection of the corporate veil, but that doesn't excuse them from their obligation to comply with the provisions of the ACNC Act and the ACNC governance standards. As we said before, a church that wishes to go down this road can apply for an ABN and seek registration status as a charity with the ACNC, which is also a service that we are able to offer you. However, in order to do so, the church will need to, the leaders will be under an obligation to comply with the ACNC Act and the ACNC governance standards. In this circumstance, the mother church can still act as the controller of the plant if desired by becoming the sole controlling member of the plant company, which helps to avoid a fairly well-known phenomenon which has been termed mission drift by some, whereby a plant or an entity which was intended to be an extension of a particular church outreach or ministry kind of ends up drifting and going its separate way. If the mother church is the sole controlling corporate member of the plant company, that helps to alleviate that scenario by ensuring that the plant, in essence, remains under the practical governance of the mother church. A church which is established as its own entity is able to lease premises or become the registered owner of premises in its own name and in its own right. And it's also a good model for larger start-up congregations where permanent premises are required. Also, we would note that corporate structuring is easier with companies limited by guarantee depending on the kind of ministries that the church might wish to undertake going forward. If your church plant's ministry is contemplated to include a school or a care arm, generally speaking, it's easier to structure that if the company is limited by guarantee than if it's simply a ministry or an activity which has been performed under the auspices of the mother church. In circumstances where the church plant is an unincorporated church, that is something that I believe Crystal was going to address with you.
Can everybody hear me? Just let me know if I'm muffled or you can't hear me. All right, so sometimes when you plant a church, you might not want to go to the expense of setting up a separate incorporated structure. And you might wish to go down the path of an unincorporated church. And of course, most of you know unincorporated churches are the way that traditionally churches have been set up. And a lot of our churches still are unincorporated. A lot of our large churches are still unincorporated. For churches that are starting, it's becoming less and less popular to start as an unincorporated church. And that is because of the current to start as an unincorporated church. And that is because of the current climate of risk. Now, especially with the Royal Commission into child sex abuse and the removal of the limitation period, an unincorporated church exposes leaders to risk indefinitely. So if you set up an unincorporated church tomorrow and an incident happens in the next 2 weeks, which came up, or came to light in 30 years' time, it's those leaders that can possibly be looked to. And, if you're starting from scratch, we're really counselling people or churches against going down that unincorporated church, road. However, it still can be the best option if the church plant doesn't want to, or the mother church doesn't want to have the church plant directly under its legal umbrella. But there just isn't the resource to fund the incorporation in the short to medium term. You can manage risk. I would just say, just be wary of high-risk activities. Make sure your child safety policies are up to date, regularly reviewed and enforced. Churches that are unincorporated can still get an ABN. They can still have a constitution. The ACCC provides an unincorporated church constitution, I believe. They still are eligible to apply for charity registration, obtain tax concession charity endorsements. Usually they won't be able to lease or own premises without a separate legal structure, but they can hire premises. A lot of unincorporated churches will do this. So they get a public liability insurance policy under their ABN as an unincorporated church, and they will hire, say, a school hall or some other premises to run their church services from. So it certainly is an option, but in the current climate of risk, it's a less desirable one than what it used to be. Of course, unincorporated, not a legal person, can't hold property in and of its own right. I've just got a question. Is it true that without ACNC registration, your offerings would be taxable? Look, not entirely, because they are donations. So the logic being that tax has already been paid on those donations. The income, it will be any income on which income tax would otherwise apply. So donations, not necessarily, but any income that the church earns, absolutely. So if it owns property and sells property and incurs capital gains tax, then it will be liable for that capital gains tax. If it engages in any sort of commercial activity, then it can be liable for tax on any income earned from that activity. It will need to pay tax on any interest that's earned on investments, etc. So that's the answer to that. It's absolutely essential for charities to have their ACNC registration in order to be, to take full advantage of the benefits. A lot of churches, the majority of churches, would not be viable without that registration. So, all right. So, you can still obtain public liability insurance, enter into rental agreements for halls, obtain officers insurance. All right, and as I said, the big ticket item is the risk that lies with the leaders and possibly the members. Now, I think I've spoken about this before, but with unincorporated churches, when the law looks at, the law essentially will look at who made the decision that led to the incident, and most times that will be the leaders. Sometimes, if the members vote on a decision, then the members can also be at risk. All right. Usually, an unincorporated church, it's a bit contradictory to the idea that they can't enter contracts, but it's not unusual for unincorporated churches to employ people directly under their ABNs, open bank accounts. It's usually the cheapest setup option for an independent church. But given that you will need to have a constitution, if you take legal advice on that constitution and then you take legal advice with respect to your tax endorsement and charity registration, there will be a duplication of costs if you then subsequently need to incorporate. And I think I've covered those. The church not being able to borrow in its own right is a big one. That's why a lot of churches that are unincorporated will set up a separate trust structure, so they'll have a separate company limited by guarantee, which acts as trustee and holds property on trust for the purposes of the church. But that, of course, then leaves you with essentially three entities, being the church, the trustee and the trust, that need to keep books and records. Yeah, and she'll talk about, so once you've decided on what kind of church plant you want to go down, you then go down to the next level and decide, okay, well, what kind of member model do I want? Let's pass over to you.
So, hello again, everybody. Please let me know once again if there are any issues. In relation to member models for the church plant, there are a couple of options available. The first of which is the open model. And the open model is characterised by the presence of the church board and leadership, which consists, generally speaking, of the senior pastor and at least two others who may be elders or leaders, recognised leaders within the congregation. Members of the congregation in good standing will generally be members of, under this model, of the church plant, and they who otherwise satisfy the membership criteria determined by the board. So sometimes it's prudent for the board, and oftentimes we will discuss this in the course of assisting people with their constitutional documents, but sometimes it's prudent to give the board the power to promulgate regulations which set out any additional membership criteria which they may like to insist upon for persons to be members. Members responsible for board elections at the AGM, the responsibility to approve changes to the Constitution, removal of board members, and members may also be able to reserve rights, or rather rights can also be reserved to the members regarding land purchases and borrowings which are undertaken by the church.
So you can reserve that function if you want to, or you can go to a model where there is no need for member approval with relation to land purchases, borrowings, or the sale of real estate.
And on a similar vein, oftentimes when members have the right to approve land purchases and borrowings, often there will be a requirement enshrined within the Constitution or the governing document requiring, say, a certain percentage approval at a membership meeting in order to proceed with the contemplated purchase. Do we have sound again? And the last indication was that we didn't have any. Wonderful. Okay, so just in terms of choices, whether the board, they can choose whether the board or the members responsible for member appointment in the church plant. Members can be appointed on nomination from the board, so the board or the leadership of the church can actually choose to nominate members, or a board may appoint a new member on nomination from an existing member.
All right, so I'll just make a comment. I'll just flick back just to that last point there, just to clarify. Just let me know if you can't hear me. So essentially, you can put different qualifiers in your constitution when it comes to the appointment of new members. So either the board or the members can appoint new members. If the board appoints the new members, then you can put a qualifier in there so that they can only appoint a member that's been nominated, a new prospective member that's been nominated by an existing member, or it can be reversed. The members appoint the new member, but can only do so if that person has received a nomination from the board. And that's a different way that you can build, different ways you can build accountability between those two functioning, I guess, organs of your church, being your board and your membership. Okay. So an open model, it can make decision-making problematic and slow, as any democratic process can be. It can increase church politics. The more people you've got, the more political it becomes. It does increase the accountability for the board. So the more power the membership has, the more accountable the board is. It can also increase the buy-in from the congregation. So the more say the congregation have, the more they feel like they're a part of the church. And that can be a criticism of the next one we'll talk about, which is the closed model, that people feel the disconnect. Okay. All right. So a closed model, a lot of churches are set up with a closed model. There's not a model that's better or worse than the other. They're just different, and different models will suit different congregations. Okay, and usually with a closed model, your board or your leadership comprises of the senior pastor and at least 2 others. Sometimes it's a number of others. Usually they're your elders or your leaders. The membership of that church will comprise of that board, be comprised of that board, plus maybe a small group of others as well, just to make that membership a little bit broader. Alternatively, as we've discussed, you can have that mother church, that incorporated mother church, as the sole controlling corporate member. So there's one member in that case, and that is the mother church company. All right. So if there's a smaller membership, those people will be responsible for board elections at the annual general meeting. Those members are responsible to approve changes to the constitution, can remove your board members. So there's no need to bring anything to the larger congregation for approval or voting. You can choose in your constitution whether or not you want the board or the members to be responsible for member appointments. Okay, and we discussed putting in those qualifiers around who those nominees can be and who can nominate them. So sometimes having that endorsement, say from a senior pastor, so anyone can nominate someone, any member, say, for a board position, but they need to be endorsed by the senior pastor as a prospective candidate before they qualify for election, for example. It just puts a few safeguards around who comes up before you for election. Obviously, a closed model is great for ease of decision making. You've got a small group of people, easy voting, easy decision making. Nothing gets backlogged in the same way as when you've got an open model. It can be very difficult, although we've done it successfully. I've seen it been done successfully many, many times. It can be problematic to transition from an open model to a closed model. So if you want to go this way, start this way. If you go the sole corporate member model, it solidifies the link between the mother church and the plant from the beginning, which can be a good thing. All right, and there are our pictures again. There are our old pictures. Okay, so does anyone have any questions coming out of that webinar, specific questions if you're thinking about planning a church, or anything that you didn't understand? No questions? Okay, if you've got any questions that come to mind after the webinar, please feel free to email us and let us know. Thank you for listening this afternoon. I apologise for the sound issues that we had. And I'll just hand over to Nikolai, who'll talk about the next webinar that's coming up.
Nikolai Arjun here, and thank you for your participation in our webinar. The next one, as you see on the slide, is on the 28th of November, and it will be on the topic of domestic violence within the church, which is a very important issue today. So I would encourage you to join our webinar again, spread the word, maybe someone you know would like to join. And this is pretty much it. And again, I'll repeat that this webinar recording will be available in a few days on our website. So thank you very much, and we will see you next time in a few weeks. Thanks, and bye-bye.